I'm joined now by barrister Chris Daw KC to discuss with him whether the sentencing of Valdo Calocane has been too lenient. Now, Chris, thanks very much for joining us here on the show. Let's deal with a few things in order. The family of the individuals who were the victims of the Nottingham killer have asked the Home Secretary to review the sentence. I think it's an indeterminate detention in a secure mental health facility. When the Home Secretary makes that determination about whether the sentence is unduly lenient, is it possible to revisit the case as to whether this individual should have been charged with murder rather than manslaughter, or is it just the sentence she can review?
Well, there's two separate aspects. Firstly, it's the Attorney General, not the Home Secretary. It's nothing to do with the Home Secretary. The Attorney General has the power to refer cases to the Court of Appeal to review a sentence if the Attorney General comes to the conclusion that it is, quote unquote, unduly lenient. As for your second question regarding whether there's a possibility of reviewing the prosecution's decision, that's the Crown Prosecution Service decision to accept the guilty pleas to manslaughter on the grounds of diminished responsibility, the Court of Appeal has no power in that regard, and neither does the Attorney General. That's a matter entirely for the prosecution in the case. And of course, in this case, the prosecution reviewed not only a number of defence psychiatric reports, but also commissioned at least one, if not two, reports on behalf of the prosecution. And the conclusion, as I understand it, was the same on behalf of every single one of those expert psychiatrists, and that is that this particular defendant was suffering from very severe psychotic illness, psychiatric illness at the time of the killings, and therefore was suffering from diminished responsibility, hence the perfectly correct and proper legal decision by the prosecutor, however unpopular it might be out there in the country, to reflect the reality of the evidence in the acceptance of that plea. This was not a murder case because this man was not mentally capable of committing murder at the time of the crimes.
One of the points that the families raised is that they didn't feel properly consulted by the Crown Prosecution Service. In fact, they've described a feeling of being bounced into this manslaughter plea by the perpetrator of this crime. Of course, they may be consulted, but they would have no say, would they, over what plea the CPS, what charge and plea both the CPS brought forward and the judge accepted?
Yes, I mean, I think that's a really important point, because you're right to draw a distinction between two different things. The first is that it is absolutely the prosecution's job and duty and legal responsibility to make that decision as to whether to accept that plea to manslaughter, subject ultimately to the judge's views. Although the judge does not have the power to overrule the prosecution, it is still a matter for the prosecution. So you're absolutely right that that decision is the prosecution's or the prosecution's alone. When it comes to family consultation, I think that's a very, very good point, because I think one of the ways in which the system often goes wrong is that those family members who have very strong views and have very strong, understandable anger and emotional reaction to the crime and wish to see the maximum possible punishment by law, which is completely understandable for anyone who's lost a family member in this way. They often feel that they're simply not, things are not explained properly, they're not consulted early enough, and that's the reason why they become angry. Whereas if people are treated respectfully and brought into the process, at least in terms of decision making and timing, then I think people are much more willing to accept ultimately that there is a proper and legitimate legal reason for the decision. In this case, I can't obviously comment on the degree of consultation that this family were given, but it does seem that something potentially went wrong. And there is a broader issue across our criminal justice system where victims often say, decisions have been made, I had no idea it was going to happen, it was a complete shock, I'm very, very upset and hurt by it. If that's happening, as it may well have done in this case, then something needs to change, and victims need to be given a more active voice in the process, even if in the end the decision goes against their wishes.
Yeah, Chris, you're right to raise that, because it's clear that in this case the family feel that they haven't been given that active voice and been properly consulted. Just turning back to the referral that the family have made to the Attorney General, Victoria Prentice, thank you for picking me up on that, by the way. As a lawyer myself, I should have got it right. But anyway, every day's a school day here on Talk TV. What can the Attorney General do if in fact she decides that this sentence is too lenient? What other sentence could this criminal be, what other sentence could be given to this criminal?
Well, none, and this is why, frankly, I think it's a political exercise. I mean, the role of the Attorney General in sentence reviews historically was a legal one as the law officer. So, in other words, taking a decision as a lawyer with proper legal advice as to whether a sentence meets the criteria for referral as unduly lenient. Unfortunately, we've seen a trend going back to Priti Patel and then followed on by Suella Braverman and others of basically responding to public outcry and referring cases to the Courts of Appeal as a result of sort of political or public pressure. That's not what the process is for. And in this case, where you have an indefinite hospital order, there is simply no other sentence that could possibly replace it, because this man will remain, as the judge said, almost certainly for the rest of his life in a secure psychiatric environment. If and when he ever recovered his mental health to the extent that he potentially could be returned to a prison environment, then that, of course, is what would happen. And so, realistically, this is simply really a fruitless exercise. And I think it's really unfortunate that the Attorney General's office hasn't simply said to them, maybe invited the families in, met with them, and explained why, legally speaking, this is in fact the correct sentence in law, as it most clearly is. And as I think most people, when they understand that there is a wealth of psychiatric evidence that this man was suffering from active psychosis at the time of the crimes, I think most, and remains a danger as a result of his mental health, I think most people would say, well, of course he needs to be in a secure psychiatric environment, just like the Yorkshire Ripper was and many other high-profile killers have been over the years. If someone's psychotic, they don't belong in a prison. They can't possibly be treated in a prison. They need to be in a secure psychiatric institution to protect themselves, but most importantly of all, to protect the public.
Chris, thank you for clarifying that for us. It's really interesting to hear from you that, in fact, this is the most severe sentence that could be given in this case. Thank you so much for joining us here on Talk TV.